But we can kind of step back and speak more broadly or generally about some other like circumstances or situations that come up a lot in these snow and ice cases. A common one is the slip and fall on a sidewalk in the days following a big event, a big snow or ice event, and someone gets really, really hurt. Now, public sidewalk claims are hard. You're not most likely going to succeed in suing a city or a town or a village under those circumstances. So if you called me and you're looking for help, like what could we do? I've had cases where, depending upon exactly the location, like which town or city this happened in, you can look to city or town codes. And there is usually language, not necessarily in every instance, but in many instances, there's language in city and town codes that actually shifts the liability of snow and ice removal from public sidewalks to the abutting or adjacent landowner. So in plain English, if you own a home or business and a public sidewalk runs in front of it, the likelihood is that you have to keep it clear. And that's not just because you're a good person or a good Samaritan, that there's likely to be a code, in the city charter or the town charter that actually mandates that be done. So you can, be found liable under the right circumstances, of course, for not properly clearing a public sidewalk that kind of borders or is adjacent to your property. And that applies to private, single family homeowners as well. Okay. There's going to be language, and I've seen it in many instances, about the timing that you're afforded as a homeowner to clear your adjacent sidewalk of snow and ice. I've seen sometimes it says you have to clear within 12 hours after the cessation of the storm. And of course you have to use reasonably diligent efforts. And that can be helpful if we can prove that maybe that wasn't done, that we, of course, the plaintiff's lawyer or the injury victim's lawyer, can prove successfully that wasn't done. So again, just because it's a public sidewalk, adjacent landowners, homeowners, business owners shouldn't be complacent. They should get out there and they should do it. And I know people watching this have probably had a variety of personal experiences just walking on these sidewalks. It happens to me too. I'll be walking through a village or a town after, days or even a couple of weeks after a snow or ice event. And you'll still encounter, really, lousy shoveling jobs, or just, very, very poorly done or half-hearted efforts put into clearing snow and ice. That's exposing those owners, those adjacent owners, to potential claims and lawsuits. Just a couple other things I want to point out. I mentioned this turn of phrase, the cessation of the storm. That's actually something that comes up a lot in these snow and ice cases. People who might slip and fall at a location in the middle of a storm. Does that expose or automatically open up liability to a property owner or a homeowner? No. The law does build in some measure of forgiveness, if you will, to property and landowners. They're not expected to be robotic and go out there constantly 24/7 during a snowstorm or a blizzard to make sure that their parking lot or their sidewalks are perfectly clear and free. That's impossible, right? So there are exceptions, which I don't need to delve into for the purposes of this video today. But the general rule is that landowners are given, some measure of time after the end of an event, after the end of a blizzard, the end of a snowstorm, to go out and actually clear their parking lot, clear their sidewalks of snow and ice. And it's a logical application, right? It's just, again, common sense. You're not going to likely have the success of keeping things perfectly clear of snow and ice in the middle of a blizzard. So whether it be a blizzard or something a little more low key, there are often times where the timing or the ending of a storm can factor into whether or not a homeowner or a property owner acted reasonably in taking care of their property after the fact. There are other elements that naturally come up with these types of cases involving, for example, weather experts or meteorology experts getting certified weather records. I've had the good fortune of teaming up with some very sharp and sophisticated weather experts to help prove cases and succeed for my clients. That can kind of take us down a different road and discussion for another day. But I just want to conclude by saying, when it comes to snow and ice cases, proving that the landowner or the homeowner had notice of the problem in some time sufficient prior to the accident is the key to prevailing in a case.